Hello, good morning. We are we are continuing studying company law. Remember, we have seen in the first video a history of company law, international company law, and the main issues that are important in this field of the international commerce law. Lex societatis, recognition of foreign companies, nationality of companies, and we have also considered the two main theories about that, the incorporation theory and the real seat theory. In the second video, we started to see the approach in the European Union, according with European Union law. And we have studied the main article in the Treaty on the Functioning of the European Union, Article 54, the most important article about international company law in the European Union. And we have seen that this article has been interpreted in a sense during decades, and how the Centro's decision in 1999 changed everything in international company law within the European Union. And now we are going to continue seeing the most important decisions of the European Union Court of Justice about company law. It's important to take into consideration this case law because in this field of the law, international company law within the European Union, the most important point is the case law of the European Court of Justice. As we are going to see, there is also directives, very important directive about that, but this directive cannot be understood outside the framework of the case law. We have seen in the previous video that it was the European Court of Justice who introduced the competition between legal orders in the European Union, when the European Court of Justice established that that any person can incorporate a company in any country of the European Union, and this company incorporated in any country of the European Union will be able to do business in any other country of the European Union. This was the main consequence of the Centro's decision. This was new, and there were some consequences of this principle. As I have explained in the last video, one of these consequences was that people from different countries started to incorporate companies in, for example, the United Kingdom, because of the nature of the United Kingdom law on companies, and the problems that now can arise following the Brexit. But this was only the first step, as we are going to see today in this video. The European Union Court of Justice continue doing law through the judgment, through the case law, in the next decisions we are going to see today. Decisions you have, I remember you have these decisions in the Moodle. I have posted a folder with these decisions some days ago. I don't remember, maybe 2 weeks ago. And then you have all the decisions we are going to consider here. And the next decision is Overseeding decision. This decision introduces a new topic in our in our problems is the transfer of seat, international transfer of the seat of the company. We are going to see now this case. This is a decision of the year 2002, November 5th, and this decision was related with a company, Overseeding, incorporated in the Netherlands. This company was incorporated in the Netherlands. The owners were people from the Netherlands, and this company was doing business in Germany and entering into commercial relationship with German companies. And at one point, the shares of the company of Overseeding were acquired by German people living in Germany. So it's not difficult to understand, as this company, although it was incorporated in the Netherlands, was doing business in Germany. In a moment, the company was acquired, well, the shares of the company, for being more precise, were acquired by German people living in Germany. And the company continued doing business in the same way. There was no change because of the acquisition of the shares. The company continued doing business as usual in Germany. But of course, there was a change, at least from a theoretical point of view, and I guess that all of you now realize this change. As now the owners of the company, the persons who rule the company, were people living in Germany, the real seat of the company was no longer in the Netherlands, but in Germany. Remember, real seat of the company, the main administration of the company, the place where the decisions about the life of the company are taken. So, when the shares of the company were acquired by people in Germany, the decision about the company from that moment were adopted in Germany. So the real seat was in Germany. But till now, this is just a pure theoretical change. But what happened? In a moment, Overseeding had some problems with a German company. And Overseeding needed to introduce a claim before the German courts. And Overseeding introduced the claim. And what happened? Then the German company, Nordic Construction, said that the action introduced by Overseeding cannot be admitted. Why? Because as Overseeding was a company incorporated in the Netherlands and the real seat of the company was in Germany, there was a dissociation between the country of incorporation of the company, the Netherlands, and the country where the real seat of the company was, in Germany. And as you know, according with the real seat theory, when there is a dissociation between the country of incorporation of the company and the country of the real seat of the company, then the legal personality of the company cannot be recognized. A company in which this dissociation exists cannot be recognized in countries following the real seat theory. So that means that as Germany follows the real seat theory, it was not possible the recognition of the company incorporated in the Netherlands, Overseeding. And when you are not able to recognize the personality of the company, this company has no capacity to introduce a claim. So the claim should be dismissed. And this is what happened in Germany. And of course, there was an appeal, and at the end, the Supreme Court in Germany, the Bundesgerichtshof, decided to refer a preliminary ruling to the European Court of Justice. And the idea was that the reasoning of the German Supreme Court was that, well, we in Germany follow the real seed theory. According with the real seed theory, we cannot recognize the personality of this company incorporated in the Netherlands because the real seat of the company is in Germany. But is this according with the freedom of establishment of the European Union? Is this according with Article 54 of the European Union Treaty of the Article 54 of the Treaty on the Functioning of the European Union? This was the question. And of course, the European Court of Justice said that is not according with Article 54 of the Treaty on the Functioning of the European Union, the non-recognition of a company incorporated in another member state. If we go to the judgment, we can see that the decision of the European Union Court of Justice was that where a company forming accordance with the law of a member state, A, in which it has its registered office is deemed under the law of another member state, B, to have moved its actual center of administration to member state B, Articles 43 and 48 of the Treaty on the European Community preclude member state B from denying the company legal capacity and consequently the capacity to bring legal proceedings before its national courts for the purpose of enforcing rights under a contract with a company establishment in member state B. That means this is the case, a company incorporated in a member state, A, the Netherlands, and which has its registered office in the Netherlands, and its real seat in state B in Germany, and in this case the courts, the authorities of state B are obliged to recognize the legal personality of the company, the capacity of the company. They are obliged to admit that this company can bring legal proceedings before the German courts. This was the decision. And it was an important decision because for some technical reasons that I'm not going to comment here. If you want, we can comment that in the meeting we are going to have next Tuesday, tomorrow. But for some technical reasons, after the Centro's decision, some authors and authorities in Germany especially thought that the Centro's decision was not enough to put an end to the real seed theory. I'm not going to comment that now. I'm going to comment that if you want in the meeting tomorrow. But this was the situation. Some thought that the Centro's decision was not enough to conclude that the real seed theory was not applicable within the European Union in relation with companies incorporated in a member state of the European Union. But after the Overseeding decision, it was not possible to deny that the real seed theory was not applicable to companies incorporated in a member state of the European Union. This was pretty clear from that point. And this is the second very important decision we have in company law in the European Union. And then we have the third important decision, inspired art. We are going to see this decision now, but very briefly, because inspired art is a decision of the year 2003. It's complicated in some way. So if you want, we can discuss more in depth this decision on Tuesday, tomorrow. But at that point now, I'm just going to say that this decision is important because the first two decisions, centros and overseeding, were connected with the problem of the recognition of the foreign companies. And if you remember, I'm sure you remember, that the real seed theory to incorporation theory have different consequences. One of the consequences of these theories is in relation with the recognition of foreign companies. As we have seen, according with the real seed theory, there is no recognition of a company when there is a dissociation between the country where the company has been incorporated and the country where the real seat of the company is. This is one of the consequences of the distinction between real seed theory and incorporation theory. But there is another consequence of the difference between these two theories, and it's a consequence connected with applicable law to companies, lex societatis. You know, each company has a very specific law that governs the incorporation of the company, the rights and duties of the shareholders, the rights and duties of the directors, and the structure of the company. This company link to this law, connected with the company is called lex societatis. And the difference between the incorporation theory and the real seed theory is that according with incorporation theory, this law, this lex societatis, is the law of the country where the company has been incorporated. And according with the real seed theory, this law, this lex societatis, is the law of the country where the real seat of the company is. This is a main distinction between real seed theory and incorporation theory. So, according with the real seed theory, the lex societatis of a company is the law of the country where the real seat of the company is. So, till inspired art, we knew that a company incorporated in a member state of the European Union should be recognized in any other member state of the European Union. And this company cannot be, the recognition of this company cannot be denied because the real seat of the company was not in the country of incorporation. So this aspect of the real seat theory was against the freedom of establishment within the European Union. But till inspired art, we didn't know whether the other aspect of the real seat theory, incorporation theory, the aspect related with the determination of the lex societatis, was also against the freedom of establishment. I mean, we know that is not possible, the denial of the recognition. But in the case that we recognize the legal personality, the capacity of a company incorporated in a country, in a member state of the European Union, even in the case that the real seat of the company is not in the member state of the incorporation. In this case, when we are recognizing this company, we are also obliged to apply to this company the law of the incorporation country, or we can apply the law of the country where the real seat of the company is. This is the problem. I hope that this is clear. Imagine, the doubt was whether a country, for example, Germany, can, according with the freedom of establishment of the European Union, once the authorities of this country, Germany, have recognized a company incorporated in another member state, according with the obligations coming from Article 54 of the Treaty on the Functioning of the European Union, if once this recognition has been made, the authorities of this country are allowed to apply to the company not the law of the country of incorporation, but the law of the country of the real estate, of the real seat of the company. Imagine, in that case, in the case Overseeding, we have seen previously, the German authorities are obliged to recognize the capacity of the company incorporated in the Netherlands. Okay, that's perfect. But is it possible for the German authorities to apply to this company the German law? For example, for the recognition of the rights, for the rights of the shareholders, for the duties of the directors, for the liability of the directors, for example. This is a different problem. One thing is to recognize the company, and another different thing is to determine the applicable law to the company. And the doubt was, as I have explained, whether the authorities of one of the countries of the authorities of one of the member states of the European Union are allowed to apply to companies incorporated in another member state the law of the real estate, of the real seat of the company, instead of the law of the country of incorporation of the company. This, as I have explained, this is a question that has been not resolved neither in Centro's decision nor in Overseeding. But in Overseeding, the European Court of Justice said something about that, but I'm not going to enter into that. And in Inspired Art, it was almost clear that the obligation of the countries of the European Union, of the member states of the European Union, was not only to recognize the foreign companies incorporated in another member state, but also to apply to these companies the law of the incorporation country. So in Inspired Art, it seems that the European Court of Justice is saying to the member states that the obligations coming from the Article 54 of the Treaty on the Functioning of the European Union are not limited to the recognition of the company, but also include the application of the law of the country where the company has been incorporated. This is, of course, important. It's not completely clear because in Inspired Art the question was referred to one specific question, the liability of the directors, and maybe we can ask whether this conclusion should be applied also in other aspects of the functioning of the company. And there are another doubts, there are further doubts about that, but we are not going to enter into these doubts now. I'm just going to say that in Inspired Art, as I have said, it seems that the European Court of Justice is establishing that the obligation of the member states of the European Union is not only the recognition of the company, but also is the obligation of these authorities of the member states are also the application of the country of the law, the application of the law of the country of incorporation. That means that the real seat theory cannot be applied within the European Union to companies incorporated in a member state of the European Union, neither in the aspect of the recognition of the company, nor in the aspect of the determination of the applicable law to companies. Remember, the distinction between real seat and incorporation theory, the distinctions are two. One related with the recognition of companies and the other related with the lex societatis. So after Inspired Art, the principle within the European Union is that the incorporation theory, the real seat theory, cannot be applied to companies incorporated in a member state of the European Union, neither in the aspect of the recognition nor in the aspect of the determination of the lex societatis. I don't know whether this is clear. Please, if you have doubts, well, tomorrow we can speak about these doubts, and we can clarify the doubts you may have about this. So we are moving to the next decision, Cartesio. Cartesio is about a different problem. In the first decisions we have seen the question of recognition of foreign companies and determination of the applicable law to companies, lex societatis. And in Overseeding, we have seen these questions in relation with the transfer, the international transfer of the real seat of the company. And in Cartesio, we are going to see the international transfer of the statutory seat of the company. So this is a good moment to stress the differences between the international transfer of the real seat of the company and the international transfer of the statutory seat of the company. When we are talking about international transfer of seat of companies, we are always talking about mobility of companies. So a company that is in a country and moves to another country, moves its seat. But as a company has two different seats, the formal seat and the real seat, we should distinguish between the transfer of the real seat of the company and the transfer of the formal seat of the company. And when we are talking about real seat of the company, we are talking about, as we have seen in previous videos, we are talking about the main administration of the company, usually the main establishment of the company, the principal establishment of the company, or the main place of business of the company. This is real seat of the company, the main administration, the main establishment, the principal establishment, the main place of business of the company. This is real seat of the company. And when we are talking about formal seat of the company, we are talking about statutory seat of the company. The the seat of the company, the domicile of the company, that is in the bylaws of the company, in the agreement of association in the company, and in the documents that were used for the incorporation of the company, the seat determined by the register of the company. Each company should be formally registered in one country, and this is also the formal seat of the company. I hope that you understand the difference. It's very important to understand the difference. I think that it's easy to understand the difference, but if you have any doubts, tomorrow we can discuss these doubts. So, in overseeding, we were dealing with the transfer, the international transfer of the real seat of the company. The real seat of the company, the administration of the company, was moved from the Netherlands to Germany. In Cartesio, we are dealing with the transfer of the formal seat of the company, of the statutory seat of the company. In that case, it was a company incorporated in Hungary that wanted to transfer its formal seat, statutory seat, to Italy. But before entering into the Cartesio case, we should clarify one point, is that when we are talking about the transfer of the real seat of the company, we are talking about a change, a factual change. And as we have seen in overseeding, maybe even the directors of the company, the owners of the company, and people who enter into relationships, commercial relationship with the company, don't realize that a change has occurred. Maybe they don't realize that. In the case of overseeding, the company continue being a company incorporated in the Netherlands, and the company was doing business in Germany as before the change of the real seat of the company. When we are talking about the international transfer, the cross-border transfer of the statutory seat of the company, usually the aim of this change is to change the law governing the company. I mean, usually when we are talking about the cross-border transfer of the formal seat of the company, we are talking about this situation. For example, a Spanish company that is governed by the Spanish law wants to transfer its seat, its formal seat, to France, to Paris, for example, not only to transfer the formal seat to Paris, but to convert itself into a French company. So, before the change, the company was a Spanish company according with the Spanish law. The bylaws, the documents of the company, the structure of the company, the functioning of the company was according with the Spanish law because was a Spanish company. And when the directors of the company and the owners of the company decide to transfer the seat to another country, to France, for example, their intention is to convert this company in a French company, in a company governed by the French law. That means the company established according with the French law, functioning according with the French law, and so on, to transfer the company into a French company. This is usually the idea of a transfer of a formal seat of the company, of a statutory seat of the company. Usually. Why? And I'm stressing the word usually, because In the Cartesio case, the intention of the company, the Hungarian company, Cartesio, was to transfer its formal seat, its statutory seat, from Hungary to Italy, but they wanted to continue being a company governed by the Hungarian law. This is not very common. This is not very common. Why the Hungarian company wanted to change its formal seat, to change its registered office from Hungary to Italy, and not becoming an Italian company? I don't know. I have a guess, and in a minute, in some minutes, I'm going to explain to you my guess, but this is not very common. And but it was the case in Cartesio. And so the company introduced an application before the Hungarian authorities in companies, asking for the registration of the transfer of the formal seat, of the statutory seat of the company, but continue being an Hungarian companies. And the Hungarian authorities refused to admit this transfer of seat to Italy, continue being an Hungarian company. The Hungarian authorities decided that a company governed by Hungarian law cannot have its statutory seat outside Hungary. The seat should be within the borders of Hungary. And as there was a refusal of the application for the transfer of the seat, the directors of Cartesio decided to appeal, and at the end, the Hungarian courts decided to refer a preliminary question to the European Court of Justice. And the Court of Justice, the European Union Court of Justice, was faced to the decision about this point. It's against or in accordance with Article 54 of the European Union, of the Treaty on the Functioning of the European Union, is against or is in accordance with this article a national law, domestic law, the Hungarian law in this case, that prevents Hungarian companies to have its registered office outside Hungary, and so they are not allowed to fix their statutory seat in another member state. This is the question. I hope that this is clear. The idea is the freedom of establishment covers the situation in which a company incorporated in a member state wants to have its formal seat in another member state, but continue being a company governed by the law of the country of incorporation. Is the Article 54 of the Treaty on the Functioning of the European Union allows companies incorporated in a member state to fix their statutory seat in another member state, maintaining that the company is governed by the law of the incorporation country? This was the question. And the Court of Justice decided that it's not against the freedom of establishment that the law of a member state prevents companies incorporated according with the law of that country of transferring its statutory seat to a foreign country, maintaining its status as company governed by the law of the country of incorporation. So, the European Court of Justice said that Hungarian law in this case is not against Article 54 of the Treaty on the Functioning of the European Union. The freedom of establishment doesn't cover the situation in which a company decides to transfer its statutory seat to another member state and maintaining the status of a company governed by the law of the country of incorporation. Maybe this is in some way surprising. I'm not going to deal now with the reasons for this result. If you want, we can comment that tomorrow. It's interesting, but we need to consider more in depth the case law of the European Union. I can say that, for example, the conclusions of the General Advocate in this case, Poyares Maduro, was in the sense that it was against the freedom of establishment that the law of a country, of a member state of the European Union, establishes that it was not possible this change of statutory seat of the company, for example. But at the end, the European Court of Justice decided in another sense, decided in another way, but it's reasonable to have doubts and to discuss about what is more accurate according with the European Union law. But I'm not going to enter into that now, because the point is that the European Union Court of Justice decided that the Hungarian law in this case was not against the transfer of the seat of the company, and this is a very important point, of course, but the most important point in the decision is not this, is other point. And it's surprising because, as you know, courts usually answer the questions we put to these courts, but usually the courts don't say anything about questions that were not the main question, or that questions that had not been discussed during the proceedings. This is very, I think, a general principle in law in any country, that the courts should decide about the problems the parties want to introduce before the courts, but the courts cannot use judgment to say, well, and in relation with this other point that it was not discussed here, my opinion is that this is not usually the position of the courts. But this was the case here. The European Union Court of Justice answered the question introduced by the Hungarian courts, the preliminary question referred from the Hungarian courts, and added something that was not in the proceedings. And the very important points for this are numbers 111 and 112 of the decision. At point 111, nevertheless, the situation where the seat of the company incorporated under the law of one member state is transferred to another member state with no change as regards the law which governs that company, fails to be distinguished from the situation where a company governed by the law of one member state moves to another member state by moving its seats to the territory of the latter, thereby breaking the connecting factor required under the national law of the member state of incorporation. In number 112, in fact, in that latter case, the power referred to in paragraph 110 above, far from implying that national legislation on the incorporation and winding up of companies enjoys any form of immunity from the rules of the EC Treaty on freedom of establishment, cannot in particular justify the member state of incorporation by requiring the winding up by requiring the winding up or liquidation of the company in preventing that company from converting itself into a company governed by the law of the other member state to the extent that it's permitted under that law to do so. So, the European Union Court of Justice says that it's possible for a member state to prevent companies incorporated according with the law of that member state to transfer its statutory seat to another member state and continue being companies governed by the law of this member state. So it's possible for the Hungarian law to say that a company ruled by the Hungarian law cannot have its statutory seat in Italy and continue being a company governed by Hungarian law. But Hungarian law cannot prevent an Hungarian company to transform itself in a company governed by the law of another member state. Remember, as I have said before, usually when a company wants to transfer its formal seat to another state, is because this company wants to transform itself in a company governed by the law of another member state. As I have said, this was not the case in Cartesio. Cartesio was a very strange case because it's not very common that a company wants to transfer its formal seat to another member state and maintain the connection with the law of the first state. This is, as I have said, this is not very common. But this was the case in Cartesio. And the European Union Court of Justice said, well, this particular case, the case in which a company wants to transfer its formal seat to another member state and wants also at the same time to maintain its connection with the first state, in this case, is not against the freedom of establishment that the national law of the states established that this is not possible, established a prohibition, established the requirement that the countries governed by the law of a member state should have its formal seat in that member state. And added, as I have explained. But the other case that, as I have said, is the normal case when we are talking about transfer of formal seat, the case in which the company wants to transfer its seat in order to convert itself in a company governed by the law of the other member state, in this case, it's against the freedom of establishment, a national law that prevents companies incorporated according with the law of that member state to convert themselves in companies ruled by the law of another member state. This is very important because the European Union Court of Justice said that the freedom of establishment of companies includes a right to the transformation, to the conversion of companies. is not only that companies incorporated according with the law of a member state have the right to establish in another member states through subsidiaries or through branches, as we have seen in the previous videos, is that these companies has also a right to transform themselves in companies governed by the law of another member states. For saying that, I have said in the first video, I think, that when we are talking about nationality of companies, we are not talking about the same idea that nationality of physical persons. I hope that this is clear. But to see the importance, the relevance of this decision of the European Court of Justice, imagine that the European Court of Justice has established that the European citizens, physical persons, have not only the right to move into another member states, but also the right to change their nationality and to adopt the nationality of another member state. You see the difference, you see the importance of that. You are not saying only that you have the capacity to move, the right to move to another member state, but you have also the right to adopt the nationality of another member state. Well, in some way, this is what, in relation with companies, what the European Union Court of Justice was establishing in the case Cartesio. I have to say one very important nuance to this. In Cartesio, the European Union Court of Justice established that the transformation of the company should be admitted by the country where the company wants to move in. So, what the European Union Court of Justice is saying is that when a Hungarian company wants to move to Italy and convert itself in an Italian company, the Hungarian authorities should admit that when the Italian authorities admit that change. So the last word is for the authorities, for the law of the new state of the company. So the state where the company wants to be, the law of the companies, of the immigration of the company, the country where the company wants to move, this law has the last word. This law should admit the transformation. And when this law admits the transformation, then the law of the departing country, in this example Hungary, cannot deny the transformation. But the last word is of this country. It was in Cartesio decision. So, coming back to the example in physical persons, the idea is, well, if, for example, a Spaniard like me wants to move to France and to adopt the French nationality, so the Spanish authorities should admit that change when the French authorities admit the change of nationality. So in the last word is of the French authorities. They should admit the change of my nationality, but when the French authorities have decided that I have the French nationality, Spanish authorities should admit that change. They are obliged to admit that change. In the case of physical persons, that is not the case because we are talking about companies. It's just to stress the importance of the decision in Cartesio, because this decision implies that the companies have not only the right of establishment through branches or subsidiaries, but also the right to change, the right to transform themselves in companies governed by the law of another country. And as I have said, this happens in companies, but this is not the situation in the free movement of physical persons. This is not the situation at all in the free movement of physical persons. So it's important to realize that here the European Union Charter of Justice has introduced a very important difference between the freedom of establishment of physical persons and of companies. Well, to resume what to make a brief to take them the main ideas we have seen till now, the main ideas, in order to clarify what we have seen till now. We have seen that in Cartesio, the European Union Court of Justice has said that it's not against the freedom of establishment that a country, in this case Hungary, prevents companies incorporated according with its law of having its statutory seat outside the country, outside Hungary, while maintaining the connection with Hungary. So it's according with the freedom of establishment a national law that obliges the companies incorporated in that country to have their statutory seat in that country. It's not against the freedom of establishment a national law in that sense. It's not against the freedom of establishment. Second, it's against the freedom of establishment the law of a country that prevents companies incorporated according with the law of that country of transforming themselves in companies governed by the law of another member state. When a company incorporated in a country wants to convert itself in a country governed by the law of another member state, and this member state, the other member state, admits this change, so the first member state, the departing member state, should admit the change. The country in which the company wants to be converted, the country of the law that the company wants to assume, has the possibility to say, well, we assume or not this change. But if the second state assumes the change, the first state, the departing state, cannot deny the transformation. I hope that this is clear. This is the importance of the Cartesio decision. Is that clear? So, we are almost in 1 hour, but I'm going to explain valid decision in this video because it's important to complete the idea, because valid decision, the next decision, and Cartesio decision are connected. So we have seen that in Cartesio decision, the law of the country to where the company wants to migrate has the last word. In that case, Italy had the last word in admitting the transformation. The country where the company wants to migrate. So, according with the Centro's decision, when the country to where the company wants to migrate denies the transformation, there is no problem with the European Union law. But now we have valid decision. Valid decision is a decision of the year, well, Cartesio decision was a decision of the year 2008, I think. Yeah, 2008, December 2008. And valid decision is a decision of the year 2012. And remember, in Cartesio, an Hungarian company wanted to move to Italy and maintaining the connection with the Hungarian law. In the valid decision, we have an Italian company that asked to be removed from the Italian register of companies on the ground that this company intended to transfer its seat to Hungary and to convert itself into a Hungarian company. So the register of companies in Italy admitted the application. So the Italian authorities deleted the register of the company in the Italian register of companies because the company wanted to convert itself in a company governed by Hungarian law. But when the company arrived at Hungary and demanded for the registration in the Hungarian register of companies, the Hungarian authorities denied the registration. So the Hungarian authorities deny the possibility of a foreign company, an Italian company in this case, to become a Hungarian company maintaining the connection with the Italian company. So the Vale directors wanted a change of the status of the company, but not a new incorporation of the company. They wanted to register in Hungary an Hungarian company, but making clear that that Italian company was the Italian, that Hungarian company was the successor of the Italian company that has changed its seat to Hungary. A transformation of the company. They wanted to register in Hungarian the transformation of the Italian company into an Hungarian company. And the Hungarian authorities more or less said, well, we can incorporate a company in Hungary, but you cannot transform an Italian company in an Hungarian company, more or less. So, if we consider the Cartesio case law, this is a case in which the Hungarian law would be not against the freedom of establishment, because remember, in Cartesio they have said, well, the authorities of the country of incorporation of the company should admit the change when the authorities of the country to where the company wants to migrate admit the change. But the last word is of the countries, of the authorities of the country to where the company wants to migrate. In Vale case, the authorities of the country where the company wants to migrate are the Hungarian companies, and the Hungarian companies said that this is not admissible. So, in principle, according with the Cartesio the case law, the decision of the Hungarian authorities is legitimate, is admissible. But when the Hungarian courts refer to the European Union Court of Justice a preliminary ruling about that, and the European Court of Justice decided about that, said that the Hungarian companies cannot deny the registration of the Italian company. They say the European Union authority, the European Union Court of Justice said that if the conversion of a company is admitted in pure domestic cases, an Hungarian company can transform into another Hungarian company, they should admit also the international cases. They should admit the transformation of companies incorporated in another member state. So this is a change, I think, in the case law of Cartesio. So we should consider at the same time Cartesio and Vale decision to say that through these two decisions, Cartesio and Vale, the European Union Court of Justice introduced the right of transformation of companies. And this is interesting. Well, my first idea was to end today with all these things, but it's not possible because we are now in 1 hour and 5 minutes, and I want to put an end to this video. But I have to say one thing more before ending. I have explained that the Cartesio case was not a very common case because usually the transfer of the statutory seat of a company to another country wants also the transformation of the company, the conversion of the company in a company ruled by the law of another state. And this was not the case in Cartesio. It's very strange. And in Vale, it's strange also because if you follow the case through the judgment of the European Union Court of Justice, you realize that the company was deleted in the register in Italy in February, I think, and it was not till some months after that that the company demanded a registration in Hungary. And you can think, well, a company that is without registration between February and November, this is strange. This is a company without activity. What is happening here? Well, it's a little bit strange. I was told that maybe Cartesio and Vale are not real cases. They are artificial cases created in order to oblige the European Union Court of Justice to say something about the international transfer of companies. This is a rumor. This is not well established, and I cannot say more about that. But if you want, we can comment that also tomorrow, but because it's also interesting and is connected with the next step we are going to see, that is how at the end the European lawmaker they deal with the transformation of companies, transfer of seat of companies within the European Union. But we are going to see that tomorrow in our meeting if you want, and we are going to continue with company law in the next video. Remember that you have in the Moodle the connection, the link for the meeting we have tomorrow at 12 o'clock. So good morning, afternoon, or evening. Bye.